we're going to go ahead and we're going to get into this. Uh, first of all, thanks Alliance HCM for having me on. My name's Andrew Nielsen. I am the General Counsel at my HR Council, and here to talk about uh, kind of a little bit of smorgasbord type of topics today. Things about what's happening coming up in the next year, things that you can do to stay um, out of hot water, if you will, going into the new year, and some things just to keep an eye on. That's enough of my face. We're going to talk about basically these four topics, and we're going to get going in the interest of time. Just some housekeeping items. I am an attorney, but I'm probably not your attorney. If you have any questions, you can feel free to slap them into Q&A. I try to look at them as we go. I've got them up over here, so if you see me looking around, I've got like 85 monitors over here. Some have my notes, some have the deck, some have my ugly mug on it. But I'll try to keep an eye on this chat window as we go through. So feel free to slap something in there if you got questions about something I'm talking about, if you need some clarification, and I'll try to get those as we go through. If not, Christina will poke me or kick me in the shins and let me know that I missed something important. As we go through, please don't hesitate to ask those questions as they pop up. Uh, First thing right off the bat, we're going to talk about some employment law changes, some things that are changing next year in terms of uh, things you're going to want to stay on top of in terms of compliance issues. So starting January 1 of next year, which is sadly less than, what's the third, like 28 days away or so, 29, 19 states are going to increase their minimum wage. That's a lot of states. Um, there's going to be 4 states that increase their exempt salary thresholds for whether or not you're an exempt employee in those states or not. And believe it or not, there's going to be even more states that happen later in the middle of the year. And not to be outdone, the cities, mostly cities and some counties, also have minimum wage increases coming. And there's 40 plus of those. So it's quite the hodgepodge, the patchwork of regulations and ordinances and laws that you have to pay attention to. It's not just federal law that says, 7.25. Now there are some states such as Wisconsin, I think Ohio, Indiana, that have passed laws that say that you can't have a minimum wage that is higher than the federal minimum wage. But then you have places like the Wild West in California, where there's numerous different municipalities with different wage and hour requirements in terms of minimum wage. And then they go even crazier based upon not only what city you're in, but what job you're doing. I'm thinking specifically of Los Angeles, and hotel workers have different wage and hour requirements than you would elsewhere in the county doing a different job, or elsewhere in the city doing a different job. Uh, I have the list. I'll show you the list in just a sec. With the exempt changes, those states that doing exemption changes, we got California, Maine, New York, and Washington. And later in the year, you're going to have Alaska is going to join them in terms of different salary threshold for being exempt. I believe that happens on July 1. Here's a pretty little map I did with the help of our AI overlords to color in the states, just for a quick graphical overview of what states are changing their minimum wage this year. As of January 1, if we add in July, we'd cover in Alaska. And I'm sure there are other states that are having mid-year increases as well. In fact, I will tell you that they are going to be um, the District of Columbia, Oregon, and Florida. I think Florida's change is eliminating something, but that's not until July. And again, 40 plus municipalities, and unfortunately, the municipalities don't follow a nice calendar year cycle like I've asked them to make things easier on us for compliance. Municipalities can kind of do things whenever the heck they want and whenever they feel like it, and they're effective usually pretty quickly after the city ordinance passes. Um, in addition to minimum wage, which is kind of basic stuff, paid leave expansion. So there is a wave of paid leave laws that I don't know if they're sweeping the nation, but they're passing all over the place. The paid leave laws in in this instance that I'm using for this slide are like the state version of paid family medical leave. So we got two states that are joining the parade as of January 1st. We've got Delaware and we've got Minnesota. Uh, Minnesota has already had some requirements in terms of notices that happened. The deadline was 12/1 if you're in Minnesota to give employees notice of what plan you're using and payroll deductions amounts and all that sort of fun stuff. Delaware also starts on 1/1. Excuse me. And we got some states that have updated their paid family leave laws. We're talking Colorado and we're talking Washington State, not DC. Those changes go into effect on 1/1. Those are just little tweaks in terms of what is already required for those leave laws. So if you are in those states, you should already have a policy in place, and you just want to make sure that your wording has been updated to comply with the new rules. And then mid-year, I think again, both July 1, if memory serves, Maine and Maryland are going to have updated paid leave laws go into effect as well. We have some interesting issues um, with OSHA going on. So if you all remember, I don't know if you remember, I don't know if you paid attention like I did, but during the first Trump administration, he delayed appointing someone to run OSHA. And as a result, OSHA didn't really get a lot of stuff done during the first Trump administration. Um, Same thing kind of is happening now in the second administration. So before the Biden administration rode off into the sunset, they passed a heat law or a proposed rulemaking about heat in indoor and outdoor environments and what employers have to do to make sure that they are compliant under OSHA. It goes beyond the general duty clause. So, a general duty clause tells employers that they have to act in the best interest of the safety of their employees. Um, it governs lots of crazy different things from bathroom rules all the way to whether or not employees can bring firearms to the premises of work. So the hot kitchen rule, my if you if you guys attended the webinar that I did for Alliance in January and recorded it, you could throw it back at me. And I think I said that I fully expected the new administration to appoint someone from OSHA to withdraw that heat rule, and I was wrong. Um, 11 months later, that rule has not been withdrawn. The rule, in fact, commentary just ended in terms of the proposed rule as of October 31st, I think. And that new rule and the final regulation should be coming down. I would expect either right at the end of the year or right after January 1st. And they have requirements for what you're going to have to do for hot environments, such as, giving the breaks, giving people access to ice water, all sorts of fun stuff. And they're going to require you to pay attention to that to make sure that you are compliant. Sorry, you hit the wrong button there. Not to be outdone, there are some states that already have rules on this. You're going to see this Pacific Coast trio. If you pay attention to employment law, California, Washington, and Oregon, you're going to see them all over the place. they I'm not saying they act in lockstep, but when California does something, then Oregon and Washington tend to follow. Um, I don't know if they have a competition, but it's definitely a pattern that you'll see. And then Minnesota has been on tear in terms of new regulations lately. So just for background, I'm licensed in Wisconsin and Minnesota. I live in Milwaukee. I used to live in Minneapolis, and the difference between new laws between just these two border states is, um, I mean, it's crazy. And what happened is Wisconsin has had a very Republican controlled legislature for the past, I don't know, 12, 14 years, maybe more. Um, and we've had a Democratic governor for, the last two terms. And they can't agree on anything, and so nothing gets passed and no laws change. Minnesota has gone and they had an entire, all three branches or all two branches of the government, two branches of the legislature and the governor's office were held by Democrats. And so they passed a lot of progressive bills, um, CEG, the paid leave law that I just talked about. And before that, the the paid sick leave law the year before and eliminating non-competes. And so it's quite they're trying to catch up to, New Jersey, California, and Oregon, I think. But um, that's what's happening with Minnesota being an outlier there. And then also to be aware of, there's no new harassment trainings coming up, but January 1st is the perfect time to make sure that you guys are doing your annual harassment training. Some of these apply to all employers, like in California, New York State, um, other places, Connecticut, I think, and others apply only to like restaurant workers or tipped employees. Like DC's got a fancy rule that is a very small carved out niche set of employees that need to have sexual harassment training. Um, but January 1 is always a great time to make sure that you're getting those done or that you have them scheduled or to go back and make sure that everyone has taken those classes and has had that training. So make sure that you're on top of that. All right. AI. I actually did a whole webinar for AI uh, and employment law. I think I did two, actually one on hiring, one on employment law in general for Alliance back in early 2024. Um, and it is not a boring area of law. Nothing has slowed down there really. It's kind of, I mean, it's kind of an ever evolving area of law that somebody's going to have to pay attention to, and that's going to have effect on employers. And there's a real debate going on if you pay attention to what's happening at the federal level. The current administration wants to prohibit states from being able to pass their own laws regarding artificial intelligence and regulations regarding artificial intelligence. Um, States obviously want to keep that. We could make an argument about whether or not those rights were expressly reserved under the Constitution for the federal government or whether or not they belong to the states, a federalism type argument. Uh, but the rule is that we're talking about, um, the bleeding edge of law. This stuff is, uh, brand new. Nobody's ever had to deal with this stuff before. And as such, any laws that are coming, um, none of them are going to be right away. Whoever, thinks they're going to write the perfect law to govern AI is wrong. Um, and so I guess that's my bias. Let's just start there. And so things are going to change pretty quickly. There's going to be laws that come down and the courts say that's stupid, or that's unconstitutional, or that's not what you can't do that. So it's going to be a interesting area to keep a hold of. Uh, for our purposes, we're going to focus right now on hiring tools. So there's a ton of AI hiring tools out there, right? Um, with ATS applicant tracking systems, you've got technology that scans and searches resumes for keywords, scores them. It puts those that score higher at the top of the pile. It puts those that score lower at the bottom of the pile and tells you who you should probably interview or not interview. Um, on top of that, you have interview chatbots. So I have, I don't think I have any client that uses an interview chatbot, but they're out there. I think that would be extremely off-putting as an applicant, but I can understand why employers would want to use that in order to speed things up or in order to, save employee time and move things along faster. AI chatbot's always there, right? You don't have to schedule around other meetings. You don't have to schedule around vacations. You don't have to schedule around, oh, my kid got sick. I had to stay home today. I can't do the interview. So uh, I understand, and I think it makes a lot of business sense why these exist and why employers want to use them. And then video analysis. This is a fun one. It's kind of like Big Brother. So they're actually real interviews, but there is an AI assistant. You know how they have AI note takers? These AI tools will analyze the camera of the interview and they'll give feedback in terms of what they think, whether or not the applicant's being truthful, all sorts of stuff. Very, Big Brother's watching type of stuff. Um, and so is all very interesting stuff, and it all is kind of it's not entirely unregulated. We'll get to that in a second. But because this is brand new, there's not a lot of great regulations on this, and there's not a lot of great case law on this. And so it's kind of caveat emptor, buyer beware at this point in terms of making sure that you're not either doing something that's currently illegal or something that will be seen to be illegal or discriminatory in a short while. As to those risks, um, like I said, top of mind for me is discrimination. And you might be saying, Nielsen, how can AI discriminate? AI doesn't think. AI just does math, right? That's all AI is a fancy math algorithm. Even though it spits out words, it's all math. It's all mathematical equations. Don't ask me to explain any more than that because I'm a philosophy pre-med major who went to law school. So that's the extent of what I can tell you. But AI, let me tell you, can absolutely discriminate. Um, and it's not because the software itself likes or disfavors someone because they're like, oh, that person, sounds like they're Polish from the south side of Milwaukee. They have a ski in their last name or they have a CZ combination. And we don't like those Polacks from the south side of Milwaukee. And by the way, I'm third generation South Milwaukee. My mom's 100% Polish, so I say that with love. Um, and it isn't that the software does that, but the software and the AI algorithms have to be designed by somebody. The AI doesn't just spring up out of whole cloth in, math. It just is programmed by somebody. So if the software developers have certain, characteristics or biases, the AI that they create is likely going to be designed uh, uh, with those biases, whether knowingly or not, in them. So there are two cases that I like to talk about from Amazon and from Microsoft. I'll start with Amazon first. So Amazon is hiring software engineers. Software engineers generally tend to go to, universities that aren't liberal arts schools, right? So they're going to be, Cal Polytech or whatever, MIT, whatever technical type universities where they have, a software program or a data analysis program or whatever. And so Amazon created a resume screener for software engineers to sift out those who they didn't think would be successful. And they built it based upon going backwards. So they said, all right, these employees at Amazon are our best software coders. What do they all have in common? And so they figured out their backgrounds, they figured out their educational background, and they used that to program the resume screener. The resume screener um, screened out a lot of women, and it screened out those that went to liberal arts schools that had the requisite knowledge and background to do the same job, just because their sample size from Amazon didn't include any of those. And so it thought that they were not going to be good fits. Amazon got in trouble for discriminating based upon sex, essentially, because it excluded mostly women, and there are some flaws with it. Microsoft, and this is, still probably 8 years ago, had, uh, like I said, an AI video analyzer sit in on interviews, and it watched the interviews and determined, whether or not somebody was likable or not, or whether or not somebody was being truthful or not, or somebody was withholding information. Long and short of it is that they found out uh, that the AI was basically racist. It gave lower scores to black males just because of their facial features and what it interpreted their facial features to be. And it turns out that's all because the people who made the software to analyze the video only fed it videos of, white males. And so it didn't understand, the AI just does math. It says, look for these parameters, not inside these parameters, bad. And so that's what happened is, it was baked in. So this discrimination is not always conscious or intentional at the AI level, um, but it ends up being discriminatory just based upon, you know, lack of oversight or lack of considering all the possible world of facts. So something to be aware of if you are doing that. Um, the EEOC has said they have rules. The EEOC came down with uh, logarithmic fairness requirements, and uh, they basically have given out guidance in terms of how you use them. It's called the Algorithmic Fairness Initiative, um, and the EEOC began scrutinizing under the Biden administration the use of AI, and it was not messing around. That's kind of fallen off the cliff with the EEOC not having quorum to make a lot of decisions during the Trump administration. I believe that is about to change if it hasn't changed already. Um, but the EEOC is out looking, or they were out looking for cases about resume scanners, virtual assistants and chatbots. And there are rules about that. So if you're using those, make sure that you're compliant with them, or that if you have a vendor that's doing it, make sure that they indicate that they're compliant with the EEOC rules. On top of all that, New York City has rules on using chatbots, and also, I believe California has rules about chatbots. And the New York City one, I can tell you off the top of my head that if first of all, you have to disclose that it's using an AI chatbot to do the interview, and number two, the applicant has the ability to opt out and ask for a real human. Um, I haven't seen any cases on that yet, because I think it's pretty straightforward, and I don't think anybody's violating it. But if you are in any of those locations, or uh, in a location that might pass something like that, um, you know, if you go back, I'm just going to go back to this map real quick. Um, you know, if you're anywhere, Washington, Oregon, California, around the coasts for sure. Then also look out for Illinois and Minnesota. Um, those are going to be the states that are going to probably be the most active on this. The Northeast, the West Coast, Deep South, absolutely not. You might get some bleed over into Nevada, maybe Arizona and New Mexico, but If you're any of those states, just pay attention to what's happening regarding any AI rules because it might come back. All right, so we talked about some changes in the law, um, and we talked about these two things already. So I said OSHA's heat plan is coming down the pipeline. Pay attention to it the end of this year, maybe beginning of next, and uh, make sure that if it looks like it's going to be implemented, which I think it does, um, is make sure that you have a heat plan. It's a written policy that you have to have. So make sure this is something that you have in case, uh, so that you're ready for it to go into effect right away, and in case you get a site visit from OSHA. Number two, paid leave policies. We talked about that. Minnesota's got a brand new one. You got some coming up this year. Make sure that your paid leave policies are either up to date if you're in a state that has an updated one, or like if you're in Minnesota that's got a brand new one starting 1/1, make sure that your paid leave policy is, in your handbook or that you hand it out as a supplement to your handbook to make sure that you are fully compliant with the laws that are going to be coming down in that state. And also, it's also always a good time. I think end of the year, January 1st, a lot of HR people do employee handbook reviews or updates. So just make sure that if you are in a state that has either a paid family medical leave requirement, or if you're in a state that has a paid sick leave law, make sure that your policy is compliant. There's always little tweaks every year. I know the state of Washington just made a tiny change regarding what paid sick leave can be used for in the middle of the year. So there's always real little tiny little things that change. Just make sure that if you have a policy in your handbook that it is up to date. Social media policies. I don't know how many of you guys spend a lot of time on LinkedIn. I probably spend more time on it than I should because it doesn't really add any value to my life. But um, it's kind of amazing to me how people are like getting into fights on LinkedIn, um, or uh, posting AI swill, or garbage or fake content just to generate, I don't know, street cred um, on LinkedIn that gets you, I don't know exactly what, but people, I've noticed a lot of it for whatever reason. Um, and this is an issue because um, there's a couple different laws around social media policies and social media posts. So the biggest thing I hear from employers tell me it's a First Amendment issue, and me being a lawyer, I have to explain to them that's not how the First Amendment works. The First Amendment only prevents the government from making laws prohibiting speech and conduct. Um, Private employer can do it as much as they want, as long as they're not violating some other law. So where that comes in is we're going to talk about the National Labor Relations Act, and where it comes in with restaurants, especially franchisees. Um, the whole issue is brand protection, right? You guys have brand standards that you've agreed to when you signed your franchise agreement. You have requirements in terms of what you have to do, not only in terms of what your restaurant has to look like or how your food presentation works, but you also have to maintain brand standards and you have to protect the brand or else really bad things happen. So, uh, what you can't do is you can't prohibit employees from engaging in what's called Section 7 activity, or protected protected concerted activities, PCA. And so if an employee is engaging in protected concerted activity and you discipline them, then they get to file an unfair labor practice against you in front of the National Labor Relations Board. And now it's going to take forever, just because I don't even know if they have a quorum yet to hear cases. But if they do, there's a gigantic backlog of cases in front of the NLRB, and these things will drag on interminably, I guess, in my opinion, after the shutdown. Um, so if an employee does something that's considered protected concerted activity, and I haven't told you what that is, but protected concerted activity is complaining about wages or safety issues. So if an employee goes on uh, Facebook, Twitter, X, Instagram, whatever, TikTok, and says, the floor in this kitchen is so greasy, it's a slip hazard. Me and my buddy almost cracked our heads falling this morning. And they posted on social media and they tag your company. Um, you might want to fire them because it's making your company look bad. But at the same time, you can't do that because that's protected concerted activity. You can't fire someone for exercising those protected concerted activities. And so it's basically like the First Amendment, for the NLRB, I guess, if you want to think of it that way. Or maybe somebody goes on social media and posts, my job at McDowell's is terrible because Mr. McDowell doesn't even pay me minimum wage and we should get paid more. That again, protected concerted activity, exercising the rights to complain about wages is protected by the National Labor Relations Act. And by the way, the National Labor Relations Act covers pretty much every single employer, unless you're a railroad or an airline. Um, you're going to be covered by the National Labor Relations Act, even if you don't have a union, even if you're a non-union shop, NLRA is going to apply. And that's something a lot of people don't think about. And so contrast that with someone says, uh, goes on and says, you know, I hate my boss, he's a jerk. Is that protected concerted activity? Maybe, maybe not. We probably need more facts. Um, or if they go on and they say, you know, uh, I go up and I smoke 12 joints and then I go to work high and I screw up everybody's order at work. Um, you know, that's not protected. That's something you could fire for. So what you have to do with your policies is make sure that you're banning conduct, not speech. So you can't ban protected concerted activity, but you can ban things that are, beyond that. Anything outside of protected concerted activity, you can fire somebody for. Um, I mentioned earlier, I'm in Wisconsin. I'm in Milwaukee. I grew up in Kenosha, right on the border between Illinois and Wisconsin. Uh, at grade school during recess, Bears fans and Packer fans, we used to get in fights, physical fights in the playground over football. Super intelligent of us and super emotionally mature of us, but fifth grade, we don't know any better. As long as what you're doing is not illegal or otherwise prohibited by law, you can do what you want. So again, in Wisconsin, I had an employer client call me. They had Packers Jersey Day. And during Packer Jerseys Day, somebody wore a Bears jersey. Um, nice troll job, I guess, but the employer said, can we fire them for wearing a Bears jersey? At which point I thought it was a joke. And then I said, absolutely. Once I learned out that it wasn't a joke because it wasn't illegal, there was no protected activity, it wasn't discriminatory, it wasn't in retaliation for any, work comp claim or complaining about harassment or discrimination. So, um, as long as your social media policy is not discriminating, harassing, or violating basically the National Labor Relations Act, Section 7 rights, you can do what you want. Just be careful, though. There are some state laws that protect lawful activity outside working hours. So if you have questions about that in specific instances, contact, your neighborhood friendly employment and labor law attorney to answer those questions for you. And we talked about the AI policies and like the Amazon and the Microsoft examples. So further on that, you're going to want to have rules not only on acceptable use of AI for HR and recruiting purposes, but you're going to want them um, for general employee stuff too. So, for example, you're going to want to have policies on what tools are allowed in HR land in terms of recruiting and applicant tracking, and what, the safeguards are to making sure they're not discriminatory. You're going to want to make sure that any contract that you have with any vendor, is going to protect you in case there is some, discrimination, unintended or intended in the software in case of a suit against you. But uh, on top of all that, you're going to want to have a policy that's going to protect uh, your company's information um, from being made public. So I think most people understand this, but when you put something in a Chat GPT or Gemini, unless you have, a segregated server, that information feeds the model, and they learn off of that. And so if you're, I'm going to make fun of Kentucky Fried Chicken because I have a friend whose dad owns a bunch of Kentucky Fried Chickens. If you put the 11 secret herbs and spices in ChatGPT and expect that to be locked in a vault forever that nobody can get to, um, you're mistaken. And so what you want to do is you want to stop your employees from putting confidential data, be them recipes, be them customer lists, be them financial results, like somebody's trying to read their balance sheet or their income statement or understand, their their revenue and model something. If you put that in the AI machine, that becomes part of it. And it, there are companies out there that have done opposition research by figuring out what their opponents or what the other companies have fed into AI and gotten answers out of it that nobody should have gotten out of. So make sure that you have acceptable use policies if you have employees that have the occasion to use AI, on what AI tools they can use, what data can't go in there, and make sure that it applies to all employees. I know that if you have a fry cook, highly unlikely that your fry cook is putting anything in AI work related, but um, you never know, and it can't hurt to have a prohibition on it, just as a reminder to let them know what they can and cannot do. All right, it's 1:40. We have about 7 slides left. We're making good time. I don't see any questions here, so we're good. And we're going to bust into I-9 and E-Verify for a sec. All right. So, uh, remote document verification. Uh, that was quite the time for 3 years, from the beginning of the pandemic until sometime in 2023, when you could do remote document verification, um, and didn't have to see them in person. It was a great time. Uh, Now you can still do it, but only if you're enrolled in E-Verify. E-Verify, again, if you attended the webinar in January that I did for Alliance, I predicted incorrectly that there would be a nationwide E-Verify law, and it has not come to be. Um, Pile that on the list of wrong prognostications that I've made throughout my life. Um, but if you are enrolled in E-Verify, and there are some states that do require E-Verify, and federal contractors also are required, I believe, to use E-Verify. But if you're enrolled in E-Verify, you can still do the remote document verification if you really want to. There is a process for it. And so if that's something that really trips your trigger, say, you know what, this job would be so much easier if I could do remote verifications again. Go ahead and enroll in E-Verify, and there's a process. I'm not going to go through it for the sake of sanity, um, and for the sake of not boring you all to death with USCIS rules. But uh, let it be known that it is possible if that's something you really, really want to do. Um, and those of you who want to do it, just make sure that you're in E-Verify. And it might not be a terrible idea to do E-Verify anyways. I mean, it's kind of it kind of, in the vein or the theme of this presentation, it's like staying audit proof. If you go through E-Verify and you verify all your employees and you verify when you hire them, um, in terms of whether or not they're legally eligible to work in the United States, I mean, that takes a gigantic question off your plate, especially with all the ICE raids and happening around this country. If that's something that you're concerned about, I-9s are great, and they're fairly easy to do. Everybody should know how to do them by now. E-Verify is like another step or two, but you have certainty there. And so if you hire somebody and they pass E-Verify and later there's an ICE raid for whatever reason and they say this person's not eligible, you can take the document, the verification from the E-Verify and wave it around, and you're insulated from liability. However, if you do it with I-9s, then it becomes an open question. So, but there's a cost benefit analysis to that. How much training time do you want to put into teaching people how to do E-Verify versus how much turnover you have versus how much time it might save or not save versus, your appetite for liability. All right. Uh, on the vein of audits, if you do have, questions about I-9 and immigration audits from ICE, these are the things that they're gonna pop up on the radar for audits. If you're in E-Verify, if you have a lot of data mismatches, they're gonna start to get you know intrigued in terms of what you're doing. Impossibility. If somebody um, signs an I-9 before they started working, I mean, starts working. I can't speak. If someone, if it was impossible for them to have signed an I-9, like before a job offer, that's something that's going to trigger an audit. Um, I went too far forward. If um, you have a lot of turnover, that's going to cause a red flag in terms of an audit at USCIS. If you hire a large batch of people, that's going to be an audit warning flag. And finally, squeaky wheels. If you have an employee that gets mad at you and leaves and drops a dime on you to ICE or USCIS, I guess more technically, that's going to trigger an audit. There are ways to prevent audits, I-9 audits, and ways to minimize your liability if you do it. Number one, centralized I-9 oversight. A lot of companies do this. HR is the only one that can do I-9s. They don't let other managers do it. If you do let managers do it, train the hiring managers on how to do an I-9 correctly. Monthly audits. This might be a little aggressive based upon your time, but make sure you're doing an I-9 audit to ensure that, if there isn't just one person doing it, that all your practices are compliant and everybody's doing things the same way and correctly. And also you can go so far as to asking your vendors if they can send you anything that shows that their systems are compliant with the USCIS rules. This is actually something that we get a lot of questions on, in terms of, is this person valid to work, especially with the revocation of TPS, temporary protected status, for some people, or if they have visa documents or green cards or work authorization cards, EADs, that expire and then they apply for a new one. Is the new receipt valid? Can they work with that? Um, so those are something that we do a lot of work with and can help you with if you guys have questions. Um, and finally, on I-9s, this is where a lot of employers um, get ahead of themselves. So the rehiring trap is when you hire somebody who used to work for you either a couple years ago or a year ago or whatever. You still have to follow the process, right? You still have to do, uh, if you have a background check, you should still do the background check. Even if you say, you know what, we know Bob, he's been great, still do it. Uh, Check the boxes. There's a reason, there's a process. Processes save you. In case of a lawsuit, in case of a complaint, you can say, why do you do this? And say, this was our process and we did it for everybody. And if you didn't do it for everybody, then you're opening the door to say, oh, either you're going to miss something that happened in intervening time, or somebody to say, well, that person was treated differently than I am, and therefore it was discriminatory. You do not want to give them that ammunition if you still can, or if you can't avoid it, I mean. So treat them like any other new hire. Um, I see a lot of issues with rehires in terms of what happens on I-9s and re-verification. I mean, you can do a re-verification on the I-9 form, or you can do a brand new I-9 form. Up to you, but make sure that you're looking at the document to make sure the documents aren't expired. So if they, 5 years ago, they gave you a driver's license in, most states they expire every 6 years or so, unless you're in Arizona, which I think they last like 40 years. Um, Make sure the driver's license isn't expired. Um, and if it is, have them present you new documentation under, section or document A, B, or C um, that you need in order to make them make sure that they are eligible to work. Um, Along with hires and new hires, things that cause risks when you're trying to go fast. Let's say you're desperate for a fry cook, and so um, to try to worry about getting them on board fast and getting them in the kitchen so that you can make money and not stress out the rest of your staff. Maybe you'll ask about the if they have a criminal history during the interview. In some states, that's fine. In some states, it's a complete no-no. So that's called ban the box rules. Some states and municipalities, it's completely illegal. Minnesota, it's illegal. I'll tell you that off the top of my head. California, it's illegal. And many other states, you can't do that. So just make sure that, again, you have a process. Follow your process. I know you rush for time. I know you're trying to make things hurry up and trying to relieve stress or relieve um, issues, but make sure that you are uh, not skipping steps because you're going to open yourself up to liability. And then digital onboarding risks. Just make sure that when you onboard employees, let's say you have, you're going to give them a summary plan description, you're going to give them a SBC, you're going to give them a handbook, and just make sure they're not signing 120 pages worth of documents in 30 seconds without reviewing them. If you can, make sure um, like they had the opportunity to have the time to review all the documents and to actually read them before they just clicked accept or submit. Finally, this is just about us, my HR counsel. Um, for lack of a better word, we're an online on-demand employment and HR law advice service. Um, there's our contact information. We sell on a per employee per month basis. So it's based upon how much your headcount is and you'll have access to us unlimited via our portal. Ask as many or as few questions as you want. We do employee handbooks too. You have questions, shoot an email to info. Dan will get back to you. You just want to browse around, there's our website. You can take a look. Um, And I see we have one question, and the question, that's a good question. What is the timeline for rehire to do a new I-9? Trying to remember. Uh, I don't know off the top of my head. I think I have to look at the instructions, and I do look at the instructions to recertify an I-9 all the time. So let me just look it up real quick. But it's in the I-9 instructions how long you have um, from the gap of employment. So I-9 recertification, right? Yeah, I believe it's 3 years. 3 years from when they left. I see. And Michelle, you do bring up a good point. Michelle says she said 3 days. You do have, this is where people get tripped up. If you have a new hire, they have to complete section one on the first day, and then section two has to be completed by the end of the third day. So a lot of employers will wait until day three and do them all. Um, and so don't do that. I mean, you can, but there's a risk if you ever get audited. Make sure that on day one, when you're doing all the other new hire paperwork, you have them complete section one. That section two, I'm sorry, doesn't have to be completed until the end of the third day. It'd be great if you can get it done right away. But I know that doesn't always happen. So uh, just make sure that you're going by those timelines. Uh, Courtney, I see Courtney has a question. If someone's license expires, do you remove them from the schedule until you have a valid ID? Um, not if their driver's license is expired, because they proved who they were when they were hired, and so their identity was valid. The thing that you need to look out for are work authorizations. So EAD cards, generally, Visa work, uh, uh, Visa work authorizations, TPS status. Those are the things that when those expire, those cause issues with the person no longer being able to work. So that's not going to be an issue with the passport. That's not going to be an issue with any of the list A documents. It's only going to be an issue with the list C documents, I think. If I remember right, those are the ones that talk about eligibility to work. List B is identity, and list A is a combination of B and C. All right. I'm not seeing any more questions. Ah, good question here. There's a question. What kind of problems can occur with expired eligibility to work? Well, at that point, if their work authorization expires, uh, they can't work anymore. So if they can't prove to you that they're eligible to work, then at that point, you're potentially letting a person who does not have authorization to work in the U.S. to work, and you're going to be subject to, if you're caught, you're going to be subject to ICE fines and all the penalties associated with, hiring, I guess, if you wanted to be blunt about it, hiring an illegal alien, um, which is not going to be looked upon favorably in this administration. Cynthia said that, yeah, is that something E-Verify monitors? Yes. So if you have an authorization for an employee that works, that is valid, and that authorization expires, you should get a notification from E-Verify that somebody's authorization is expiring and they need to renew it. If you don't use E-Verify, what you would do is you would have to create some sort of tickler system. Either it could be a plain calendar, it could be a paper list, I suppose, if you're into pen and paper. But something that reminds you that this person's authorization expires on X date, and that you need to have it re-verified upon the expiration of their authority to work, authorization to work. or else. And usually I set those at least 30 days before the expiration if you can, to give them time uh, to get the documentation together. And that way they know that they got to do it. You don't say, hey, today your EID expired today. I need a new one. You want to do it, you want to give them time. Sometimes they need to renew it. Sometimes they need to get a receipt for a renewal. So you want to make sure that you give them ample opportunity to do that if they can. All right, we're almost at the top of the hour, and I think we've exhausted our questions. Uh, so if anybody has anything else, you can contact me at that info email address that was up on the screen. Um, other than that, it's been a pleasure uh, spouting legal information at you all. Um, if anybody has anything else, just let us know.